People of the state of Michigan versus Willie James Jr. Motion for a new trial and amendment of judgment that you filed. Is that correct, sir?
Yes.
Counsel, he did this in pro per?
That is correct, Your Honor. And the signature on both the motion itself and the certificate of service that Mr. James signed indicated as much.
The motion is denied for multiple reasons. It addresses prosecutorial misconduct. The court saw none of that. Had I seen that during the trial, I would have addressed it immediately. Additionally, as to jurors, we watched jurors very closely, and again, we saw no juror misconduct as alleged. These are appellate issues, and certainly.
Let's pause right here. This is a critical legal moment. The judge is shutting down the motion for a new trial, and not casually, decisively. Claims like prosecutorial misconduct or juror bias are serious, but they require clear evidence. And what the judge is saying here is simple. There was none. That's huge, because if misconduct had been found during trial, it could have triggered a mistrial immediately. Instead, the court is pushing this into the appeals lane, meaning the defense now has to convince a higher court something went wrong. Question for you. Do you think this was a fair call, or should the court have dug deeper?
You will have 42 days to appeal and to request appellate counsel.
Another issue that Mr. James wished me to bring up on his behalf as it relates to jail credit, if I may. He's currently credited with no credit because of the dead time issue, because he was on parole at the time. And I can find no statutory or case law that would support this position. Therefore, I don't feel that I can ethically make it myself. But Mr. James wishes me to bring this issue to the court's attention and preserve it. And I told him that I would do so on his behalf. And I believe his argument is that he was essentially ready to be off or discharged from parole. And he was kept on there for another month while this matter was being investigated, but not yet charged. And he was charged with it the following month. And therefore, he believes that he should be entitled to the credit that he has served while this case is pending because of that. Again, my reading of the statutory and case law does not support that, but he wished me to make that challenge on his own behalf, and I told him I would do so.
I know no situation, case law, or statute that provides for that on behalf of the people.
This exchange might sound technical, but it actually reveals a lot about how sentencing works. The defense is trying to squeeze in jail credit, essentially reducing the time the defendant serves. But there's a major obstacle. He was already on parole. And under most legal frameworks, that creates what's known as dead time, meaning no credit applies. Even the defense attorney admits the law doesn't support the argument, but still raises it to preserve the issue for appeal. That's strategy, not optimism. It makes you wonder, are they playing the long game here, hoping an appellate court sees something differently?
Your Honor, thank you. The defendant was on parole. He is not entitled to any jail credit, and there is no statute or case law that would support that position. We'd ask that that request be denied.
Request is denied.
Threat to security of penal institution or interference with the administration of justice is currently scored at 0 points. We are requesting that this be scored for 10 points for the offender otherwise interfering with or attempting to interfere with the administration of justice directly or indirectly violating a personal protection order. Your Honor, in this case, the record is rife with the defendant's interference with the administration of justice. Even if we look at the conduct of lying to the police in multiple interviews and misleading the police in multiple interviews, and even if we simply look at cleaning up the vehicle to remove bloodstains from it to deter police in their investigation, that would sufficiently score 10 points for OB-19. But understanding that the jury found this defendant culpable, guilty for this homicide, getting rid of Mr. Watson's body would be the ultimate act of interference with the administration of justice. So for those reasons, we ask that 10 points be scored for OB-19, Your Honor.
Your Honor, I'm opposing that request, and I believe it's properly scored where it is. Certainly, the Department of Corrections in preparing this report would have been familiar, I think, with the facts as they were presented at trial or the facts as alleged.
OB-19 is properly scored at 10.
Your Honor, thank you. That will change the currently scored offense variable range from 65 to 100. That will ultimately change the range from an F2 to an F3, 360.
Now, this is where things escalate fast. What we're hearing is a debate over offense variable scoring, and it directly impacts how long the defendant could spend behind bars. The prosecution is arguing for additional points based on interference with justice, lying to police, cleaning evidence, even disposing of the body. If accepted, it dramatically increases the sentencing range from a lower tier all the way up to potentially 50 years. That's not a small adjustment. That's life-altering. So ask yourself, does covering up a crime make someone more dangerous than the crime itself?
5 months to 600 months on the minimum, or a minimum range of 30 to 50 years.
I never thought about killing a person, but what's the purpose of throwing their body away? That's not just hurting that person, you're hurting the whole family. Because now we don't have that closure of burying my son. And he knows exactly where his body is. And he's had over 5 years to tell us that. But you got to be a really evil person to think that's not relevant. Or if they don't have a body, then they can't prosecute me. And then they turn everything around in the end. He could have told everything he said this year, he could have said it in 2021. He could have told us where the body was when we was looking for the body, when we didn't even know my son was deceased. So I just think he's a really evil person, and I hope he gets everything that he deserves, because he do not deserve to be a free man, to walk the streets in the city that we live in, because I've never heard nobody say nothing good or positive on his behalf ever, especially in the past 5 years. I never met a person like that.
This right here changes everything. Legal arguments fade into the background when a grieving mother speaks. Her words cut deeper than any evidence because they reveal the human cost of this crime. No cloche, no video, no answers. And perhaps the most haunting part, she believes the defendant knows where her son is and chose silence. That's not just a legal issue, that's a moral one. It raises a powerful question. Should withholding that kind of truth carry its own punishment?
Never want to meet a person like that.
We are asking that the amount of that restitution be held in abeyance pending the cost of funeral or celebration of life. As the pre-sentence report indicates, they have been waiting to conduct those services based on the outcome of the criminal trial. So we ask that restitution be ordered and that the amount be held in abeyance. No legitimate rehabilitative potential. At 57 years old, this defendant has now amassed his 17th criminal conviction, 10 felonies and 7 misdemeanors. The defendant has served 2 lengthy terms in the Department of Corrections, and neither of them have rehabilitated him or educated him or helped him develop any empathy. And it turned homicidal in 1998 when this defendant was convicted in another state of second-degree murder and second-degree assault with a dangerous weapon. And we ask this court to consider for a moment, Your Honor, what does it mean when a defendant has murdered not just one person in his lifetime, but 2 people? A defendant who has already served a 10-year commitment in the Department of Corrections for murder in another state, then waits another 10 years and murders somebody in our community. I want you to think about that. Most people go through their life, Your Honor, managing not to murder anyone, let alone 2 people. And if they have the good fortune to be released and to get out of one murder conviction after a lengthy term of incarceration to come back into our community and commit another homicide, that indicates to us, Your Honor, that this is an unrehabilitatable, violent, and homicidal individual that stands before you. In fact, in 2018, this defendant was convicted of assault with intent to do great bodily harm and felony firearm in connection with shooting his girlfriend Your Honor, he served another lengthy prison term in the Michigan Department of Corrections, and he was on parole at the time he murdered Andrew Watson. Think about that for a moment. And that then leads us to the instant offense. We want the court to consider some of the facts of this case. Consider, Your Honor, how much blood was inside of that vehicle. Blood that had soaked into the seats and all the way down into the rails of the front passenger seat. Blood that had soaked into the back carpet so densely that the defendant had to remove that carpet to avoid detection. Blood that was so soaked and throughout that vehicle even after 2 professional cleanings. And what does that tell us, Your Honor? That this is a massive homicidal, lethal event that this defendant with a prior murder conviction perpetrated on this man inside of his car. And after that, Your Honor, as Ms. Watson so accurately said here today, the defendant then disposed of Andrew Watson's body. And we want you to think about for a moment, Your Honor, consider what it means to actually dispose of a whole human being. We have cases pending that have gone through the Ingham County Circuit Court in the last month where we see what happens when people are caught disposing of bodies. We see what that really looks like. But just because we don't have Andrew's remains, don't forget what that means to dispose of a whole human being such that he has vanished off the face of the earth for 5 years after an intense investigation. So this defendant is violent, he is homicidal, he is antisocial, he is an extreme risk of danger to our community. To deter this conduct, to protect others from this repeat offender, the defendant must be sentenced to a lengthy term in the Michigan Department of Corrections. Given the defendant's age, Your Honor, his parole status, it is the people's position that the defendant should be sentenced to a term of incarceration in the Michigan Department of Corrections of no less than 35 years on the minimum sentence. And that again takes into consideration his age. If he was 20 years old, we'd be asking for every day of 50 years. But given his age, at least 35 years in the Michigan Department of Corrections.
The prosecution is painting a very clear and very damning picture. This isn't being framed as a one-time mistake. It's a pattern, a second homicide, a history of violence, multiple chances at rehabilitation that, according to them, failed. And they're emphasizing something juries and judges take seriously: escalation. From assault to murder to another murder. That narrative builds toward one conclusion. This isn't someone who can safely return to society. But here's the question. Should a person's past define their entire future, or is there ever room for redemption?
Will ensure that he remains there essentially for the rest of his natural life. Thank you.
He had his day in court. He was able to tell his side of the story to the jury. The jury rendered a verdict against Mr. James. We have to respect that. Mr. James maintains his innocence, as is his right. The jury found that this was not an act of premeditation. The pre-sentence investigation report writer indicated that they found Mr. James to be polite and cooperative during his interview with them. And I would note that that largely mirrors my interactions with Mr. James as I've worked with him on this case over the last few years. I would ask the court to not exceed what the Department of Corrections recommended as an appropriate minimum sentence for Mr. James. And I would ask the court to sentence him, to consider sentencing him near the bottom end of his guidelines. Thank you.
Anything you want me to know, sir?
Say my version of the events.
I can't hear.
Gave my version of the events on the stand. See which one you want to say.
Your history says it all, as does these actions, as does the mountain of evidence against you, sir. While you maintain your innocence, it is not to be believed. It is incredible testimony, as we say, which is not to be believed. The amount of blood, the amount of effort you went through to hide your crime, cleaning the car, not once, but twice. Disposing of an entire human being without a trace, that takes some planning and forethought. That takes some knowledge. You have the history your second homicide, and in between that, a lot of violent crimes. You haven't learned your lesson. This court does not believe that you will ever be rehabilitated in this lifetime. We cannot tolerate any more gun violence in this community over anything, unless it's self-defense, and there is absolutely no evidence that what you did was done in self-defense. And you hid the body from the family. I hope that in the years that come, as you are locked up, you find it in your heart to reveal to the family where their loved one is. They deserve that. And it is only a cold-hearted, inhumane person who will continue to hide their loved one from them. I am remanding you, sir, to the Michigan Department of Corrections for 600 months to 1,200 months. That's 50 years to 100 years. I believe that is proportional.
And there it is, the final decision. A sentence of 50 to 100 years. The judge makes it clear, this isn't just about punishment, it's about protection. A pattern of violence, a lack of remorse, and the chilling detail of a body never recovered all factored into this outcome. No jail credit, financial penalties imposed, and restitution still pending, all reinforcing the severity of the case. But beyond the legal outcome, this case leaves us with bigger questions about justice, rehabilitation, and accountability. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
To the homicide, to the hiding of the body, to the long-term criminal mindset that you've had that continues not to diminish, but to escalate. There's no credit because you were on parole. You will pay a crime victims assessment amount of $130. And waiving fines, costs, attorney fees because you are indigent. You'll pay a $68 state cost, and I'm holding in advance the cost of the funeral and or celebration of life. And that money will be paid to Andrew and Otilla Watson, his parents. They deserve, at a minimum, that.
Your Honor, I have a notice of appellate rights form that has been filled out and signed by Mr. James. We would ask if the court could accept that for filing.
My clerk will accept that, get that filed, and you'll have your appellate counsel.